appeal are heard in the matter of MD and another, and the Secretary of State for the Home Department.
Yes, Mr. Butler.
My Lord, could I begin, please, by addressing two questions that my Lord asked yesterday? And could I do that by handing up a note which I've just passed up?
Certainly.
Thank you.
The first question was whether the trafficking directive is retained law. And our answer is yes, under Section 4 of the 2018 Withdrawal Act, as explained in the notes. That provides that rights contained in EU directives that were enforced in any UK courts prior to the implementation of the period completion date continue to be
we're fairly obviously familiar with the provisions about retained. We just want to check this was retained.
And it is retained in our submission because Article 11 of the directive, which deals with trafficking support, was enforced by the UK courts.
Yes, I see. Well, I don't know how much this is going to be controversial, but it's just useful to know. Mr. Tan, have you had a chance to look at this?
I haven't had a chance to look at the note. We have separately been looking at the question. We would certainly agree that the issue is not free from doubt. So it may well be retained legislation, but there is the potential for some argument about that. What I do agree with my learned friend, though, is that the issue doesn't arise in this case.
I don't think it does, but I just want to be... Could I ask you to look at it? I promise if it's controversial, we will not want to decide it. But if when you've looked at it carefully, it's not controversial, it would be useful to say so.
I will have a look at it during the morning, and perhaps I can come back to this when
Yes, I mean, if you have, more important is to listen to what Mr. Butler says. So we won't mind getting an email tomorrow saying that the note is agreed or isn't agreed.
I'm grateful.
And in the very unlikely event we think it's more important than you do, we may have to ask for further written submissions.
Of course.
Okay, that's very helpful, Mr.
The second question was whether the previous non-statutory guidance specified the level of financial support payable to victims of trafficking.
Yes.
And the answer that I gave my Lord yesterday, we still think is correct. And you see that at paragraph 13 of the notes. That's what the previous non-statutory guidance said. It didn't identify the level of support or cross-refer to the...
I see. So literally, and this looks like to be the case from the case law, the authorities are supposed to look at the contract.
Precisely, and that's what was done in Kay's case.
Yes, exactly.
And that part of the note I have run past Mr. Tam, and that I understand to be agreed. I'll of course let him speak for himself on that. Now,
okay.
Not necessarily
no need to speak now. We don't want to bounce you. Thank you. Someone's done a lot of work on this, and we're grateful.
Yes, not me. I'm grateful.
We're grateful to them.
Miss Christie, yes. Where we got to yesterday, I first submitted that MD and EH suffered loss because of the Secretary of State had remedied the Article 14 breach earlier by putting in place the individualised needs-based system. Then both MD and EH would have benefited. Separately, I submitted that the Secretary of State's response to the finding of Article 14 breach hasn't been levelling down, so that the normal position, as I put it, identified by Lord Hoffman, applies. The normal position being to place B into the same position as A. I was then turning to the submission that the payments of child trafficking benefit to groups 1 and 3 were at least from March 2015 to April 2020 not anomalous, and that's the submission I'm now going to be developing.
Give me those dates again.
March 2015, the inception of the contract.
Yeah.
April 2020, the amendment of the statutory guidance to relate to the asylum support rates.
Got it. Yeah.
So there was, I should say, an earlier contract entered into in 2011 between a different department, the Ministry of Justice, and the Salvation Army, but no one's been able to identify the details of that. From March, as I say, from March 2015 to March 2020, which was when the first version of the statutory guidance was made, the document which set out the support scheme was the contract. And you've got extracts of the contract in supplementary to page 161. I should say you've got the front piece of the Ministry of Justice contract at page 158, where we get some of the details of it. So 161 is the contract between the Secretary of State.
Oh, you've got it, what, simply because at some stage in the litigation you were supplied with it?
We were given this, yes.
Okay, hang on a second.
So in relation to the 2015 contract, we've got extracts beginning at page 161. You don't have the complete body of the contract, but we have read it all, and it is available. And it's referred to, insofar as there are gaps in the document here, they're filled in by the reference to the contract in Kay's case. And what it says is that the Salvation Army have to comply, Salvation Army being the other contractor, have to comply with Schedule 2 of the contract. And in part, Schedule 2 deals with financial support payments, and those are set out at page 166.
Yes, fine. More work from Mr. Christie, or perhaps you can make Mr. Anderson do it. Could we just have, again, so that in a judgment we can set this out formally, the provision which says Schedule 2 applies?
Yes, I can remember it's clause 8.1, but we can provide you with.
No, I don't, well,
we
no,
can provide you with chapter and verse because we've certainly done it in another case.
Well, all right. Thank you.
So it's 166 is the bit of Schedule 2 that deals with financial payments. Looking at clause F001, the contractor.
So sorry, you're going too fast for me. Well, which page? 166.
Page 166.
Yes, thank you.
Part of Schedule 2.
Yeah, I have it.
Part dealing with subsistence payments.
Yeah,
clause F001. The contractor is defined in the contract to mean the Salvation Army.
Yeah.
Shall provide service users. They're defined in the contract to mean potential victims of trafficking.
Yeah. Potential, but what about actual?
Well, the contract says potential. But it doesn't matter for my purposes because during the relevant period, EH and MD were potential victims.
So they were. Wouldn't mind knowing whether that's just Mr. Tam worked for Mr. Anderson. Can we just check whether that's a mistake that he only refers to potential victims of trafficking?
We'll check that.
Thank you.
It's in the definitions section of the contract,
Which we do have.
which I think you've got some of.
I see.
But not all.
Yeah, I have got the relevant part. I've just been looking.
We'll provide, as I say, we will provide the court with chapter and
Yeah,
verse on that.
thank you.
With subsistence payments, which are not a defined term, in cash, and these subsistence payments to be paid to the potential victims of trafficking on the following basis.
So they're not a defined term even though they're in capitals.
Quite.
Okay.
The table then identifies the subsistence payments for 4 classes of service user, and the level of support, which changes, as one sees in the second column, is defined by the form of accommodation in which the victim has been placed. And it applies to all victims, whether or not they have children.
Yeah, so the basic point is that if you are in catered accommodation, if you're you get less because you don't have to buy food.
That appears to be the logic of it.
Yes, so £30 for food, effectively, is what this means. Yep.
The third category in that table concerns potential victims of trafficking accommodated by the authority. The authority is defined in the contract to mean the Secretary of State for the Home Department.
Yes, and in K, it was acknowledged that that was just badly, can't mean what it says. Is there a reposition of what it actually means?
So on the right hand, I think what my Lord's referring to is in the right hand column where it says £65 minus the amount of subsistence received by the authority.
Yes.
That was recognised to mean from.
Yep.
Yeah. Received by whom from the authority? Must mean by the service user.
Yes. Yeah. And so that clearly means that a person accommodated and in receipt of subsistence payments under the asylum support scheme scheme, which is how the Secretary of State for the Home Department provides support, that person falls into category 3. Now, one can see that none of the subsistence payments in that table are means tested. And with the one exception, being the third category, there is no provision for set-off in respect of any income from any other source. Now, before I come on to the next bit of this page, which I'm going to come back to, because it's the bottom bit of the page that deals with child trafficking payments, but before I come on to that, could I please deal with the amendment to this bit of the contract that was attempted by the Secretary of State and dealt with in Kay's case?
Yeah.
Now, if space allows on the bench, I wonder whether we might keep that open.
We have
while I
very
turn to Kay's
capacious benches, especially in this court. Yes.
So Kay's case is volume 1 of the authorities at tab 19. And as Mr. Tam has already explained, what happened was that on the 1st of March 2018, the Secretary of State issued a contract change notice to amend the contract. And it amended the part of the contract we've looked at to provide that no trafficking support at all would be provided to victims of trafficking who received asylum support. And that was challenged, and the decision is Kay's case. And if the court would please look at page 599, you'll see the reference. Oh, I got the number wrong. I'm sorry, my lord. If you look at paragraph 11, it's clause 8.2, not 8.1 of the contract. And then the judge sets out.
Sorry, where were you looking at? Page 6 in K?
Page 599 within K.
Yeah.
Paragraph 11 refers to clause 8.2 of the contract.
Yep.
And then paragraph 12 sets out the table that we've just looked at. And then the judge made 2 observations of paragraph 13. The second observation is the one that we've already dealt with, that by means from. But the first observation he makes is the one that I want to emphasise, which is that the entitlement is non-means tested. The victim of trafficking gets the sum irrespective of whether he or she is receiving, for example, voluntary payments from a kindly relative. And so, and then I could say that at paragraph 14, the judge sets out how the set-off operates under the contract in relation to asylum support. Now, we would observe that what this judgment did is to make it clear to the Secretary of State, if she didn't already appreciate it, that she was operating a non-means tested scheme and that the only set-off was in relation to asylum support. The judge then recorded the Secretary of State's position in paragraph 15, where he says that Mr. Sheldon, the Secretary of State, is in difficulty disputing the plain meaning of this contractual term, that's the asylum set-off, but says that it's a mistake and that it was never intended that a victim in the third class, i.e. a victim of trafficking who's seeking asylum, get more than the weekly subsistence payments for general asylum seekers, presently £37.75. And it was in light of the Secretary of State's understanding of what the contract was supposed to say that she issued a contract change notice which removed trafficking support for those receiving asylum support. That was the rationale for the contract change notice.
Hang on 1 second. That's the contract change notice which sparked the proceedings in K.
Exactly.
Yeah.
And that is explained by the judge at paragraph 17 to 21, but I don't propose to take the court through it now. The judge held that the contract change notice was irrational because it was based on a misinterpretation of the existing contract. And so he quashed it. And as Mr. Tam explained yesterday, it was also held that the cut in support to those receiving asylum support reached Article 14 in two ways. First, in that it unjustifiably treated victims in receipt of asylum support less favourably than victims not in receipt of asylum support. Direct discrimination.
Hang on. Yeah.
And secondly, that it unjustifiably failed to treat asylum seekers who were victims of trafficking differently from asylum seekers who weren't victims of trafficking. Failure to treat differently.
So
Liminals. And the order that the judge made was not only to quash the contract change notice, but to order back payments of trafficking support to asylum seekers who had suffered the cut. You've got the order in the bundle. I don't propose to take you to it unless you want me to. It's at page 606 of this bundle, paragraphs 4 and 5.
What's the reference?
Page 606 of Authority 1, paragraphs 4 and 5.
Can't be page 606. Must be page.
No, it is.
Sorry, can't be authorities 1. Must be authorities 2.
Authority Bundle 1, tab 19, page 606.
It's at the back of
Oh, I see.
The back of tab 19.
Oh, I see. Yes, sorry. Okay, the order's just following on. Yep.
The Secretary of State didn't seek permission to appeal.
So the claim here was being advanced by reference to two different comparator groups. In the first case, asylum seekers.
Yes.
And in the second case, in the first case, victims of trafficking.
Yes.
And in the second case, asylum seekers.
Yes.
And
Exactly.
one was treating more favourably and the other was not treating differently.
Exactly. And I would just observe that the Secretary of State was able to correct the mistake quickly and simply. She didn't respond by setting up a whole new scheme to fix the discrimination. She just increased the rate of payments to asylum seekers and made arrangements for back payments.
Just restored the rate
Yes.
prior to the contract change notice.
Put the contract back as it was.
Yeah.
And in my submission, that rather illustrates that the Secretary of State could, if she wanted, have introduced a rule with immediate effect that victims of trafficking in receipt of mainstream benefits or work income would stop receiving child trafficking support. It's a relatively easy mechanism to introduce. But as I've already pointed out, she has chosen instead to carry on making child trafficking payments.
The back payments were not under Section 8 of the 1998 Act. They were paid simply, they were directed simply on the basis that they were sums that were due.
Well, there was, the order doesn't say on what basis the back payments are being made. It's a little difficult to see as a matter of administrative law how one could order back payments prior to 3 months before the claim on a common law basis.
Quite.
So it may be that the judge had Section 8 of the Human Rights Act in mind, but he certainly doesn't say that's what he's doing.
It doesn't look as though it was argued, does it?
No.
I mean, presumably what happened was you got his decision, which which I dare say by the end of the argument you were anticipating, but you got it was a reserved case. You got the decision, and then were asked to agree an order,
Exactly.
and the Secretary of State said, "I'll pay back pay." So it was never argued.
No. From my recollection, that's right. Unless there's anything more on K, I was going to ask you please to put that away and return to the contract.
Yeah, that's fine, thank you.
So back in Supplementary Volume 2, page 166.
Sorry about that. 166.
166. So we're back on the page of the contract at the table, and you may already have noted what's said underneath the table, and that's the paragraph that makes additional provision for victims with dependent children. It specifies the rate of £20.50 for the first child and £13.55 per week. One can read in for each additional child. Now, the Secretary of State's evidence in this case is that she has no record or institutional memory of the purpose of those payments. That is recorded at paragraph 21 of the judgment below. We would make the observation that the rates of £20.50 a week for the first child and £13.55 a week for each subsequent child were plainly insufficient to meet the children's essential living needs.
On what basis? Just, you say, judicial common sense?
Well, firstly, common sense. One can't feed, clothe and look after a child on £13.55 a week, but also by reference to the asylum support rates, because the asylum support rates are the minimum that the Secretary of State assesses as necessary to meet a person's essential living needs.
Do we know what the rates were?
Well, we don't know exactly what they were in 2015, but they were something around £37.75.
You say that, and I dare say you're right, but
we can find the figure, my lord. I don't have.
Well, I think if it's an important part of your submission that there was a mismatch between the rates payable to children of VOT, victims of trafficking, in 2015, and those payable to by way of asylum, I don't think I want to assume anything.
No. Well, let me. I'm sorry, I don't have the figure now. Could I supply it by lunchtime? If we can.
Hang on 1 second.
Even on the assumption that it's 37.75, I may be being slow, but why does that mean 20.50 for the first child with 13.55 for each additional child is obviously insufficient?
Because it's 37.75 for each child.
Oh, that's for each child. Sorry.
The present rate is 39.63 for each child. And so my submission is that this figure can only have been intended to be a supplement.
Well,
to support provided by other routes. Now, can I make, before my lord questions that proposition, could I develop it a little? And we say that that makes sense. It made sense to have a supplement figure because there was already a complete framework in place for meeting the essential living needs of children in this country. Namely, if you have leave to remain, the children's needs are met through work income or mainstream benefits. if you claim asylum, the children's needs, essential living needs, are met through the asylum support system. And if you are unlawfully in the country, so if you don't have leave to remain and you're not claiming asylum, then the state still ensures that the essential living needs of children are met through Section 17 of the Children Act. That is the obligation of every local authority to meet the needs of children in need in their area. And just to illustrate that,
Do we have that provision?
you have got that in the bundle.
Okay.
In MD's case, to illustrate this, in MD's case, from May 2018 until she began receiving asylum support, her children received support from the London Borough of Brent under Section 17 of the Children Act.
In what form?
In the form of a cash payment of £155 per week.
£155 in total.
In total.
For
Not
how
per
many
child.
children?
She had 2 children.
So that's £72.50 each.
Yes. It may have been calculated on the basis of her needs plus the children's needs, on the footing that the children's needs could only be met if she was also fed and clothed.
Oh, well, all right, that's very fair of you, but that's actually rather an important point.
I don't have the breakdown of it, but if one could, I think, fairly divide the figure into 3.
The judge doesn't deal with this aspect at all, does
No.
he, his judgment?
No,
Was
he
it argued before him?
It was certainly it's in evidence, and I think the point was argued.
Okay, well, don't
I made
worry.
a submission
It's a point I hadn't focused on until now.
No.
But the 155 in any event, and you don't have a breakdown.
We don't have the breakdown.
You do know that it arises as a result of Section 17 of the Children Act.
Yes, we do know that. That's in evidence and wasn't disputed below.
But your point, I suppose, doesn't depend on what the amounts are. It simply depends on the fact that there is a system.
Exactly. Yeah. And the point is there is a separate system for all 3 groups which covers essential living needs. Now, the state treats those groups differently and assumes they have different essential living needs. That's why you get more money by way of mainstream benefits than you get by way of asylum support. But all of those benefits are targeted at essential living needs. And MD, because she wasn't receiving asylum support, was also entitled to child trafficking support.
What,
During
you mean
the-
£39.60 or whatever it was?
Well, whatever it was precisely between May.
Well,
and
I don't like this term child trafficking support because it is tendentious. I think we ought to be described what it is called in the documents in question. It appears here to be called an additional subsistence payment.
Well, I'm happy to call it the additional.
Well, but then it's called something different in the guidance.
Yes. I'm not trying to be tendentious.
No, all right.
If you have a better term, I'm quite happy to adopt it.
Well, I'm not going to suggest one. Okay.
So the point I was making was that this additional payment, whatever one calls it, was something that MD was eligible for and ultimately received in relation to the period May 2018 to the time she received asylum support, because she wasn't receiving asylum support. And now, it wasn't paid contemporaneously, I should say that. It was omitted at the time, but was then back paid.
What the Section 17?
The additional payment sum was back paid to MD by the Secretary of State.
Well, is that of any significance?
Well,
But you're talking about we talk about the £20.50.
Exactly.
Or,
Exactly. So the point is that because she
there's no dispute that she was entitled to that.
No.
So this is just a red herring.
Yes.
But Lord, I'm sorry to interrupt. We will need to check that because this isn't a point that's. I I think it wasn't even
About it being paid late?
about being back paid. Any of that.
I think Mr. Butler has accepted it's a red herring. You check it if you like, but I'm not going to pay any attention to it. It's not relevant to the legal issues, is it?
Well, what the learned friend is trying to do is set up an alternative factual case which is entirely contrary to the judge's findings of fact. And we've made this point already.
Well, he has a respondent's notice, so he's entitled to try.
Well, he's entitled to try. I accept that. But these points, I mean, the suggestion, for example, that there was a back payment of the 2055 plus £13, whatever, for this
Mr.
period
Tam,
is entirely...
honestly, you're quite right to stand up for your client. I've already said, and I think Mr. Butler has accepted, I don't at the moment see that's relevant to any of the issues we have to decide, and therefore I am wiping the last 3 minutes from my mind as far as the reasoning is concerned. Lest my ladies say they're not. I think that's it.
Lord,
Mr. Butler, that is the case, isn't it? If I may say so, it shows the danger of just throwing in a kick at the Secretary of State, whether or not justified, unless it's actually relevant to your case.
Well, I wasn't trying to kick out at the Secretary of State. I was just trying to give the court the full picture. Can I say, just to make the point, my Lord, I'm not giving evidence. This was in evidence. And can I just give
No, you can't. Look, because this is a complicated case, and I do not want to get... if it's part of your case, you must explain why, and then, of course, we must look at the evidence. If it's not part of your case, it's simply an extra complication which doesn't address the issues. Which is it?
Can I explain what is
All
the
right.
important part of my case? What I would ask the court to note is that in MD's case, from May 2018 to the time she received asylum support, she received £155 a week from Brent by way of Section 17 support. And that as a matter of the contract, that entitled her to the additional subsistence payment for her children. That's all I need to say.
So what as a matter of contract, what entitles her? The fact she got Section 17 payments.
The fact that she wasn't receiving asylum support meant that she was entitled to
Yes.
the additional.
Well, that's clear from this.
Exactly. I'm sorry to confuse things. That's all I needed to say.
Yeah. Okay.
And
Mr. Butler, as far as I understood it, you were only trying to explain about whether there had or had not been a back payment because you didn't want to mislead the court.
That was exactly it, my lady.
I'm sorry if my interpretations were less charitable. Mr. Butler.
And if the court wants the reference to where I have taken the evidence about the £155, that is Supplementary Bundle 1, page 41, paragraph 4.
But so we be clear about this. This is purely illustrative. I'm not saying you're not entitled to illustrate it. Your point is that if you are here without leave to remain and are not in receipt of asylum support, Section 17 applies. That would be a good point, whether or not actually your client had been paid.
Exactly.
Yeah.
This is illustrative.
As it had, and in fact, for reasons we needn't go into, you aren't telling us that EH was. Maybe she didn't claim it, or maybe it wasn't entitled to it for some other reason.
Well, I think the answer is, we don't need to work it out. I think the answer was that she got asylum support sooner.
Yes, I see. Well, that may well be the answer. Yeah. Okay. What was the reference for the receipt of the £155 a week?
Supplementary Bundle 1, page 41, paragraph 4.
Thank you.
And so the submission that all of this is in aid of is that the additional payments must have been intended, I say, to be supplemental. Now, the contract, as we can see at 166, said nothing about set-off in relation to these additional payments. So whereas the table says that they're set off in respect to the £65 for those receiving asylum support, the bit below the table doesn't say anything about set-off. But despite what the contract said, the Secretary of State interpreted it to mean that no child payments should be made to those in receipt of asylum support. And could I show the court where that's set out? It's in the same bundle, supplementary bundle 2, at page 3. Same bundle.
Yeah. Yeah, this is the exchange of correspondence with
Exactly. And so what one doesn't have a date on the letter at page 3, but one can see from the index it's 27th of August 2019, and it sets out the Secretary of State's understanding how the contract is supposed to operate.
Yeah.
And that, in my submission, is reminiscent of the position that the Secretary of State took in Kay's case.
This has never been subject of judicial determination.
There hasn't been the subject of judicial determination. It was the subject of challenge in OH's case.
You say that as if we know about it.
And you've got
Right.
I was just taking a breath.
You're doing well. It is very condensed stuff. You're doing extremely well. OH.
That's referred to in supplementary bundle 1 at page 88.
88.
88.
Thank you.
This is a witness statement from Ms. Nicolau Garcia, who is OH's solicitor and is also MD's solicitor. And if you, within that statement, please look at page 96.
Sorry, my bundle was 20 bits. Just give me a second to reconstruct it. Yes, page 96.
Page 96. She describes OH's case. And then at paragraph 24 on page 97, we see that case settled by way of a consent order, which provided for back payments, including in respect of the child element. OH being an individual who was a victim of trafficking and received asylum support. I don't place any particularly great weight on this, I just say it for completeness.
But the Secretary of State's position as revealed by the exchange of correspondence with the Salvation Army is consistent with Mr. Tam's case, but you would say, but it's not at the centre of your case, that the settlement of a claim challenging that is inconsistent with Mr. Tam's case.
Yes, but my primary point is the contract says what it says.
Yeah. It's not on any view a well-drafted document.
It's not, but that's the best guide. It's the only guide, in fact, in my submission, that we've got to the purpose of the scheme.
Well, okay, now I will give you what you say it's the only guide. We have two other guides, you might think. One is the description as a subsistence payment. And to me, although the term subsistence can mean different things in different contexts, as I think Mr. Justice Mostyn said, it does seem to me to be concerned with something like the concept of essential living needs. The second reason is that, leaving aside the debate about the exact status of ECAT in English law, it is clear that the Secretary of State was, broadly speaking, setting up this scheme in order to comply with her obligations under Article 12 of ECAT. We'll have to be reminded about what the exact language of that is, but subject to you showing me different, that too seems to be concerned essentially with minimum living standards. And therefore, you might be said with essential living needs. Now, that being so, you say there's no evidence as to the intention of the additional payments for children. but it might be thought that it was sufficiently clear from the context and from the description of subsistence payments that they were additional payments for their living needs.
Could I give my answer?
Please, yes,
to that?
that was my intention.
I accept that at face value, as a matter of ordinary language, one might treat subsistence as meaning subsistence, that is, money needed to live on. But as Mr. Justice Mostyn said in Kay's case, and as my Lord just suggested, subsistence means different things in different contexts. And what Mr. Justice Mostyn said was that in the trafficking context, subsistence covers two things, two separate things. It covers one, essential living needs, and it covers two, recovery needs.
Well, I have to be careful about that because the children are not victims of trafficking, unless they are. But I mean, these are the ones who aren't.
Absolutely. But of course, the whole premise of this case, the reason that this case has been brought, is because MD and EH missed out on their recovery needs because of the costs related to children. And so it's perfectly conceivable that somebody with dependent children has higher recovery costs. The point I'm making in answer to my Lord's question is that once one accepts that subsistence covers two bases within the trafficking context, one, essential living needs, and two, recovery needs, it's perfectly consistent for the contract to refer to a supplemental payment which is geared towards recovery as a subsistence payment. And then to answer the second point that my Lord made, we absolutely accept that this scheme was set up to comply with the UK's obligations under ECAT. But ECAT absolutely does not limit itself to subsistence needs in the sense of essential living needs. It explicitly says in Article 12 that it's directed to physical, social, and psychological recovery.
Yes, but that very runs into the same difficulty about the children who may, they may themselves have been born in this country, not unless they are victims of trafficking, not having recovery needs in that sense.
Well, they don't have recovery needs.
No, right. It comes back to your same point.
But it comes back to the same point, which is this. I pressed yesterday whether I needed to take the court to the evidence of it, but I understood it to be accepted that based on the judge's findings below, MD and EH had unmet recovery needs because of costs relating to their children.
No, I understand the point.
And so if one reads Article 12 ECAT, those were unmet recovery needs that Article 12 ECAT mandated. Now, I don't want to get into the, if I can help it, get into the thorny question of whether this also separately amounted to a breach of Article 12 ECAT and therefore whether ECAT Article 12 is justiciable because it's incorporated.
We don't
by
want
the
you
policy.
to, and I perhaps speak for myself, I would have thought that it's entirely relevant to refer to ECAT because we know that that is part of the Secretary of State's purpose. And if that's all you're doing,
Yes.
speaking for myself, it seems to me utterly orthodox.
Yes.
Mr. Tam will have to persuade us it's unorthodox.
Yes.
Just on that, didn't the judge say that what was being provided fulfilled the Secretary of State's obligations under ECAT?
He did.
In terms?
What he said was that there was no obligation under ECAT to meet childcare costs.
Can we see that passage?
It's paragraph 36, I think. Oh no, that's the argument.
No.
Sorry.
page 115,
Yeah.
the Secretary of State's policy judgment is not contrary to the UK's obligations under the UCAS. Into the first line at the top of 115. But we've challenged that insofar as we need to challenge it by way of the respondent's notice, because we don't accept that's right. Because if, as the judge found, you have unmet recovery needs, then the state isn't meeting its obligations under Article 12 ECAN.
Well, I see exactly how the argument goes on this. That's very clear.
So, I think I've got to the end of what I wanted to show the court on the contract, unless there are any other questions that arose from it.
Not so far as I'm concerned.
Thank you. Then I need to turn next, I think, to statutory guidance.
Yes.
Which is supplementary to page 168.
And we have those two versions, 1.00 and 1.01, but they're only a month apart, is that right?
That is right.
Okay,
So page 168 is the first version of the statutory guidance that was promulgated in March 2020. And the court may have noted that in Kay's case, Mr. Justice Mostyn criticised the Secretary of State for not having complied with the duty to promulgate statutory guidance sooner. This is the first version. And if you would please look at page 169, paragraphs 15.35 to 36. Those paragraphs reiterate what is stated in the contract.
Well, there's no 15.35 is not. It's not the bit of the contract we've seen anyway, because the bit of the contract we.
15.36 reiterates.
Yeah.
And then 15.37 provides for set-off in respect of adult trafficking support in exactly the same way as the contract. And then 15.38 provides that the child element, whatever one calls it, won't be provided to those who receive asylum support. Now, that gave effect to the Secretary of State's understanding, but is different to what was stated in the contract. And it's that rule, the introduction of that provision, which gave rise to the unlawful discrimination.
Well, surely the Secretary of State's understanding and implementation of that understanding will, on your case, have given rise to unlawful discrimination.
Just thought precisely the same thing, my lord. That's absolutely right. So that's what I wanted to show you about the March 2020 version of the.
And sorry, just 1538 refers to NRM support.
Yes.
Um,
That's the umbrella term for this trafficking support.
yes. I think it's abandoned shortly afterwards, isn't it, actually? Maybe it isn't. Anyway,
It's sometimes called NRM support, it's sometimes called VCC support, victim care contract support. It's the name of the contract.
Anyway, it's the same thing.
Same
Yep.
thing.
And sorry, an utterly trivial point, which you'll have to forgive me for. There seems to be a complete inconsistency. Sometimes dependents are spelt as dependants, which I think is the correct noun, and sometimes dependent, which is the correct adjective, I don't want to be particularly about this. I want to just use the normal formula. In the statute, it says dependant, doesn't it? Certainly in the asylum.
In the asylum,
Which I think is correct.
I think it's correct.
Well, leave it. We will struggle with this later in judgment writing. But I just wanted to check there isn't any.
There's no magic in that.
No. Okay.
The point I want to emphasise, of course, in the first version of the statutory guidance is that it carries forward the rates of 2050 and 1355 that one sees in the contract.
Yeah. No, I understand that. So this is really just the VC's. This is just the contract under a reformulated as guidance, subject to the point that the Secretary of State's understanding of its effect is spelled out in 1538.
Exactly.
And then everything changes.
Everything changes. Page
a month later.
171, 1 month later. I don't have the exact date. I don't think it's been published. Maybe Mr. Tam can help. But
These versions are not given precise. They're just given monthly dates. It might have been 1 day later. It might have been 60 days later. We'll never know.
we haven't actually got a definitive answer.
All right.
If you want it, it's tab 4 of the authorities. I won't ask you to turn it up, but we've got a list of the precise.
All right. So what is the formal date of issue of version 101?
First, my lord is pretty close. First published 24th of March 2020, and then the April version. It's according to the website. 1st of April, there's a Welsh version of the statutory guidance is added. 6th of April, there's a temporary change to the policy on the move-on period. It doesn't say that there was any amendment to the rates in April 2020, which I'm about to show you. So maybe it was the 1st, maybe it was the 6th of April. But anyway, you've got
Well, Mr. Tam, this is not the most important point in the case, but because it is slightly odd that it changed so quickly, we wouldn't mind knowing
We'll see if we can find
a
out.
precise date.
So, this version begins page 171. The bit that we've already, Mr. Tam has taken you to is at page 172, 173, and we see that the child element is increased to match the essential living needs payments made to children under the asylum support scheme.
Yeah.
And could I make 2 observations about that?
And that's the only material change, but it's obviously important to your case.
Exactly.
Okay. Let me just write that down.
As Mr. Tan pointed out, there are also then some additional payments for pregnant women and maternity grants, which also track asylum support provisions.
Hang on 1 second then. But so far as victims of trafficking are concerned, so far as children are concerned, I'll start again. So far as the victims themselves are concerned, the rates are unchanged.
Yes.
What changes is the rates for the children and the addition of the pregnancy and maternity rights.
Yes. So we would make 2 observations about this. The first is that the amendment was obviously made 5 years after the scheme was promulgated and well into the period of discrimination complained of. So even if those payments became anomalous in April 2020, that doesn't, in my submission, affect EH's claim from January 2018 to April 2020. Or MD's claim from October 2019 to April 2020. second point I wanted to make is that given that the Secretary of State's evidence was that she doesn't know why the contract was formulated as it was in March 2015, the April 2020 amendment can't, in my submission, cast any light on the policy intent in March 2015.
But isn't that the same as the first point, or am I missing it? That's I've just written down your first point.
Well, I'm sorry if I've repeated the point, but that's what it is.
Okay.
Having shown you the contract and the guidance, can I make 9 points arising from those documents? The first point is that there's no means testing or set-off under the trafficking support scheme for the adult component of trafficking support for any victim except those who receive asylum support.
Sorry, you say for adults, I mean, you mean for victims?
Yes, for the victim themselves.
Yeah.
But it's always an adult victim because children are dealt with separately.
Dealt with separately,
under local authority.
Okay.
Second, similarly in respect to the child component, so there's no means testing or set-off under the trafficking support scheme for the child component of trafficking support for any victim except those receiving asylum support. And third, that means that the support scheme doesn't provide for any set-off for those in receipt of mainstream benefits,
Yeah.
but we say that isn't an anomaly in respect of mainstream benefits for those in receipt of income from paid work or other charitable support or local authority support or those who are supported by family or friends. And so I'd ask the court just to look back at what is said in Van Raalte. The European Court...
This is all part of your third point.
This is part of my third point. The European Court noted that a key feature of the scheme, that was the contribution, a key feature of that scheme was the obligation to make contributions didn't depend on any personal entitlement to benefits. And so therefore, an exception would run counter to the grain of the scheme. Just for your note, that's Authority, Volume 2, Tab 37, page 1302. Sorry, I think the paragraph number is paragraph 41. And that meant that the exemption of men in that case would have been an anomaly, just as the exemption of women was an anomaly. But by contrast, we say here, a key feature of the scheme was that it wasn't means tested and didn't generally provide for set-off. And in that context, it was the imposition of set-off for just one group, those in receipt of asylum support, that actually ran counter to the scheme. Exactly the same is true of the other example that Mr. Tam took you to in the case of M against the Secretary of State for Work and Pensions. If the discriminatory rule had been stripped away, then the anti-abuse clause would have applied and would have applied to all. By contrast here, if you strip away the rule in issue, one's left with a non-means tested, non-set-off scheme. That was all by way of the third point. The fourth point is that, just to give you an impression of the numbers supported by the scheme, I won't ask you to turn it up, but I'll give you the reference to Mr. Ryder's statement, which I think you will have already seen. Supplementary Volume 2, page 129, paragraph 40. And he says that there are about 5,000 victims of trafficking at the time of his statement, and less than a third of those were victims of trafficking receiving asylum support. And so the set-off, which is applied to those receiving asylum support, applies to a minority of those supported by the scheme. And could I just say, I'm not sure that it's necessary to get into it. We don't accept the unevidenced assertion that only a few dozen victims of trafficking fall into Group 3 who receive the child element. And we say that in part because the Secretary of State's Permission to Appeal skeleton said that 1,600 victims of trafficking had dependent children. And there's no reason to suppose, we say, that there's a higher concentration of victims of trafficking with dependent children in the asylum support group than the other groups. And that would suggest that there are, on the back of an envelope, about 10 or 1,100 victims of trafficking entitled to the child component in groups 1 and 3 taken together. I don't ask the court to make any findings to that effect. I'm just explaining why we doubt the figure that's been advanced orally by the Secretary of State. That was my fourth point, just numbers. My fifth point is that, as I've said, the trafficking support scheme doesn't provide for any set-off for any income other than asylum support, insofar as the mainstream benefits system does or doesn't provide for set-off in relation to trafficking support, well, that is an issue in my submission for the Secretary of State for Work and Pensions and the mainstream benefits regime. If, for the sake of argument, trafficking benefits should be, but aren't, set off against mainstream benefits, then that's an error in the mainstream benefit system, not an error in a non-means tested trafficking support system. But I should say that there's no provision for set-off of trafficking support in the Universal Credit Scheme. And as Mr. Tam touched on, that was known about, or should have been known about, when the trafficking support scheme was introduced, because Universal Credit came in by regulations that came into force on the 29th of April 2013, 2 years before the trafficking support contract. And then also, there was no, and still is no, provision for set-off of child trafficking, the child element, under the legacy benefits system. Just want to make sure that the court appreciates this point. Ms. Tan's witness statement said that there was such a set-off, but that was corrected by a Part 18 response. Could I just give you the reference for that? It's Supplementary Volume 2, page 147, paragraph 3.
References again, please.
Supplementary Volume 2, page 147, paragraph 3. Coming back to the trafficking support scheme, we say it's part
We're still on your point 5.
Yes. It's part and parcel of the scheme that it's non-means tested and provides for no set-off, save for asylum support. The absence of set-off or income thresholds for those in receipt of work income, family, charitable support, mainstream benefits, we say isn't anomalous. It's part of the essence of the scheme. Rather, it's the denial of the child component for those receiving asylum support, which represents a departure from the norm. Sixth, there was a logic to having a trafficking support scheme which wasn't means tested. It's the same with any non-means tested scheme. Such a scheme has the merit of simplicity of administration. It's both easy to administer and ensures that everyone has their recovery needs met. Now, of course, the price of non-means testing is that it results in the provision of financial support to those who have other income with which to meet their recovery needs. But it's the same with any non-means.
When you say means testing, it's not really the right phrase, is it? You mean no system of mutual deduction?
Yes. But if one were to carry it through logically, it would constitute means testing, because one would also want to have set off in respect of work income or...
No, but what I meant by means testing is that in order to qualify, you have to produce evidence that you have that's the normal use of means testing is you have to satisfy the benefit giver.
Yes.
That your means are below a certain level.
Yes. No, I see.
And that's not really what we're talking about here. You're talking about no system for deduction of benefits, other forms of benefits.
Yes. Well, it doesn't matter. I mean, I do characterise that as a form of means testing, but nothing turns on the label. Then the seventh point is that the child element was also liable to aid the recovery, the trafficking recovery needs of those on mainstream benefits.
Sorry, would you say that again? The
Yes,
child element.
The child element, so the £20.55,
Yeah.
was also liable to aid meet the recovery needs of victims in receipt of mainstream benefits. And I say that because mainstream benefits are also intended to meet essential living needs. They're not given to provide a surplus. They're not given to spend on luxuries. Now, it's the case that the calculation of essential living needs is different under the mainstream system.
The concept, the phrase essential living needs is not part of the universal credit system, is it?
It is not, but that's the upshot of it. It's there to meet the day-to-day costs of living, to enable people to get back into work and to look after their children and to be housed and so on. I should also say that the only evidence that was before the court below relating to the payment of the child element to those in receipt of mainstream benefits was from a victim called XY, anonymised as XY. She is a British victim of trafficking and received mainstream benefits. And her evidence was that she too needed the child element in order to pay for childcare to attend recovery-related appointments. Could I just give you the reference to that, please, rather than taking you to it? It's Supplementary Volume 1, page 220, paragraphs 11 to 12 and 31 to 32.
just want to be clear, throughout this case, both below and here, the feature, the factual scenario which you focused on, which I quite understand, is the difficulty experienced by the claimants and by others, no doubt, including XY, of what to do with a young child, a dependent child, when you're going to a recovery-related interview. And that may be, I don't know, what has particularly triggered these proceedings. But that is purely illustrative, isn't it, of what these proceedings are about. There's no suggestion that these payments are intended for that purpose.
No, it is illustrative.
Yeah.
But what we have focused on are those needs that relate to both being a victim of trafficking and recovery from trafficking, and relate to having a child. And the cost of
Are there other
childcare,
examples of that?
there are other examples.
Just give me some. I don't need factual. I mean, just
No, so
conceptually.
there are a series of examples in the evidence relating to increased travel costs, because if one has to take children to an appointment with solicitors, one can't spend as long as at the solicitors, and so the appointments need to be broken down into more appointments. That increases travel costs, and there's plenty of evidence that.
Yes, I'm sorry. No, that's a refinement. Again, I'm not trivializing it, but that's a refinement of the same essential point. It's about the fact that you have to be accompanied by your child when going to see solicitors, but it could that in principle be true also about therapy or any other recovery-related activity. Other examples in a wholly different field of where a payment, where having a child increases the financial costs associated with, specifically with a recovery, as opposed to simply feeding the child or the child themselves.
Well, the two examples I've given are examples of recovery costs relating to having children.
I was asking for others.
But there are others. There's an example in the bundle of a victim of trafficking whose 4-year-old child was held while she, as leverage while she was forced into sex trafficking. And that child has psychological needs that need to be met.
Well, then that's a different point.
No, the child wasn't treated as a victim of trafficking himself.
No.
The only trafficking support was provided to the mother. But that would be an example where the child...
I know, I'm sorry, this all sounds very clinical, but I'm just trying to understand your particular point, which is important to your analysis, that in certain circumstances, having a child increases the financial costs to the victim of addressing the victim's recovery.
Exactly.
I got that. But the only examples you come, I'm not being critical, I'm just trying to identify what we're really talking about. The only examples you come up with are to do essentially with the victim attending some kind of session necessary for their recovery, and having either to take the child with them, additional travel costs, or have someone else look after the child.
Okay. Well, those
now, if those are, it's not a terrible thing to admit those are the examples, only examples you can think of, but I just need to...
It's not that they're the only ones they are the only ones I can think of, but that's because they're the only ones that are evidenced, and there is a wealth of evidence of those costs.
All right, thank you. We've explored this as far as we can. Don't worry, it's not a...
No.
Not necessarily, it doesn't matter, because that's what
I
it's
just want
about.
to check I haven't missed anything. I'm reminded, of course, that there will be, no doubt, many other examples of increased costs related to having children. But that's not the point.
With
I can't rely on
that's not my point.
I need to rely on those which are related to recovery.
Yeah.
So that was my 7th point. My 8th is that the judge below found that, as I would have it, the carve-out from the non-means tested scheme, which denied the child component to asylum seekers, his findings were that that meant that single parents victims, like the respondents, were left with unmet recovery needs, in that they were unable to attend the appointments for their recovery. And I rely strongly on paragraphs 52 to 54 of the judgment. So not only did the discriminatory rule represent a departure from the non-means tested or non-set-off nature of the scheme, but it also, in my submission, represented an anomaly in the scheme by leaving some victims with unmet recovery needs. That was the whole point of the scheme.
Your 9th point?
9th point is that one can readily see why the Secretary of State now considers it sensible to replace the non-means tested, non-set-off scheme with a scheme that assesses individual need, including through means testing. But that's not the correction of an anomaly in the existing scheme. It's a new policy choice. And that's, in my submission, vouched by the proposed solution and the recognition that introducing means testing will require the creation of an entirely new scheme that will take at least 11 months to introduce, and not simply a new clause which introduces set-off. So what does all that mean for the damages? Well, if we go back to Wilkinson, once it's recognised that the discriminatory rule is a departure from the generally non-means tested, non-set-off scheme, and leaves victims like the respondents with unmet recovery needs, then it can be seen in my submission that the normal view described by Lord Hoffman should prevail. The treatment of those who aren't subjected to means testing or set-off represents the norm, and those who are disadvantaged by the discriminatory rule should have been treated better. Or to put it in Lord Brown's words, if it was thought appropriate to have a non-means tested, non-set-off scheme which paid the child component to non-asylum seekers, regardless of their means, then asylum seekers were worthy of the same treatment. That was all by way of an additional submission to add to my primary submission, which was that if the Secretary of State had equalised the treatment when the issue was raised, the respondents would have been financially better off. That's what I was taking a rather long time. That's what I was proposing to say about pecuniary damages. Can I deal with the other issues much more quickly, I hope?
Yes, of course. Do you have an approximate estimate as to when you're likely to?
Well, I think I must leave Mr. Tam at least half an hour. So
I think at least half an hour. Let's see how we go. See if you can finish in half an hour. That'll leave him 40 minutes.
Yes.
Well, Mr. Tam, maybe that you don't feel you need more than.
Well, if I have 40 minutes, then I think I can complete what I need to say. Some of it may have to be a bit compressed and done by reference.
Well, I'm sure we can cope. See how you go.
Yes.
We'll arrive at a fair outcome, I'm sure.
Thank you, my Lord. So, non-pecuniary damages. Could I ask you please to look back at the judgment, core volume, page 120. paragraph 127, although there was no deliberate targeting, the treatment of the claimant has been egregious. Expression that the court looked at with Mr. Tan. Now, I accept that that relates to the respondents having suffered greatly as a consequence of the sex trafficking, paragraph 1 of the judgment.
Oh, I see. So you say that's what the judge meant by egregious.
Yes. And to what the judge recorded as being the uncontroversial fact that the respondents hadn't had their recovery needs met, paragraph 54.
Hang on one second. Sorry, what was your reference to?
I was referring to two things. One, suffering greatly through sex trafficking, paragraph 1.
Yeah.
And 2, the uncontroversial fact that the respondents hadn't had their recovery needs met, paragraph 54.
Is that what you described as egregious?
Yes.
Right. Those two features.
So
you
far as
said
I can
below
remember.
was egregious.
Well, I don't think I was actually referring to the what they suffered as victims.
Right.
But
You would
but I would
referring to
accept
the
that
unmet need.
I would accept that one could read the judgment as referring to that too. And then, if you would please note paragraphs 131 and 132, what the judge found was that the delay in implementing a scheme that would meet the respondents' unmet needs must have caused them added distress. Paragraph 132, third line, added distress. And paragraph 132, last line, and paragraph 134, last two lines, the judge is expressly talking about added distress that must have been caused by the discrimination.
When the judge says in 132 that the fact that the Secretary of State is not taking the discrimination particularly seriously weighs with me considerably, that rather suggests he's taking a punitive approach.
Well, that's, I understand why my lord says that. That's not how we read it.
Yes, I see. You put your weight on the passages you've identified.
Yes. And so, in my submission, the simple answer to this part of the appeal is that the court can only interfere with the judge's order for an assessment of non-pecuniary damages if it identifies an error in the reasoning. It can't interfere, of course, on the basis that it would have come to a different view. And in my submission, there was simply no error in the judge's approach to non-pecuniary damages. And I'll try and do it quickly, but in support of that submission, could I just show you the judgment in sternum, which is Authority Volume 1, tab 13. The question in this case was whether the first instance judge had been entitled to award £300 in damages for distress caused by a breach of Article 5.4 of the Convention in relation to a delayed parole board hearing in circumstances where an earlier hearing would not have led to earlier release. So it's purely distress damages. Section 8, subsection 4 of the Human Rights Act requires the court to take into account the principles applied by the European Court in relation to an award of compensation under Article 41. What does principles mean, given Strasbourg's tendency not to articulate statements of principle? That's dealt with at page 362. Perhaps given the time, I could just ask you to note paragraphs 30 to 32, where Lord Reid says that one has to treat principles in a broad sense.
Yeah.
Lord Reid then surveyed the European case law on non-pecuniary damages in Article 5.4 cases. His conclusion is at page 369. Paragraph 53, it's apparent, therefore, that the general practice of the European Court is to apply Article 41 on the basis that the failure to decide the lawfulness of detention speedily, which is what 5.4 requires, causes harm in the form of feelings of frustration and anxiety, which damages should be awarded. And then this is the next sentence that I rely on. It also appears that the court is prepared to presume such harm without direct proof, consistently with its approach to non-pecuniary loss in other contexts.
So far as someone in detention is concerned, that's a rather particular case. That's why you're emphasising other contexts.
Exactly.
Where are the other contexts?
He doesn't say.
Scordino.
Oh, sorry, so the Scordino, Article 6.1, absolutely. But I'm also going to show the court in a moment the Article 14 context.
In a domestic discrimination context, you would have to produce proof of general damage,
Well,
injury to feelings.
it would be preferable, but it's not in my submission. It's open to the court to infer from the surrounding facts and from the surrounding evidence that the individual has suffered distress by discrimination. That's if one applies, because if one takes the approach that one should get no less than in Strasbourg, and Strasbourg's prepared to infer from the surrounding circumstances, one would end up with less in the domestic courts than one would get in Strasbourg.
Well, that's a rather mechanistic approach. I would have thought Strasbourg would respect the practices of domestic courts on questions of proof at particular points.
Well, that may be right, but if MD and EH had their claim dismissed on, say, justification by Mr. Justice Kerr, being refused permission to appeal to the Court of Appeal, then gone to Strasbourg, and Strasbourg had come to the conclusion that Mr. Justice Kerr reached on direct discrimination, then they would have been entitled to rely on inferences as to distress. Moving to page, if I may, to page 373. If I could ask you to note paragraph 66. The particular proposition is that the recognition that where an individual suffers through mental illness, a court would be readier to infer distress.
So, sorry, which paragraphs are we on?
Paragraph 66, page 373.
And how does that help us?
Because both of the claimants suffered from serious post-traumatic stress disorder.
But that was as a result of the treatment, not as a result of the...
Yeah, the same is true of the individuals who are being referred to in Sternum. It's not suggested that the delay caused them mental illness. It was the pre-existing mental illness which made them more susceptible to distress as a result of discrimination.
And then there's a reference in 66 to, in this specific case of a prisoner awaiting a parole board hearing, one is looking at delay of 3 months or more.
And then at page 381, paragraph 96, I just wanted to note that Lord Reed says that turning to Mr. Sternham's appeal against the quashing of the award of damages, appeals in my view be allowed. The Court of Appeal was wrong to take as its starting point the treatment of wrongs under the common law. Following Greenfield, the starting point at this stage in the development of the remedy of damages under Section 8 of the 1998 Act should be the practice of the European courts. And then if we might go back to the beginning of the judgment where Lord Reed helpfully sets out the summary of his conclusions, page 357. Just to show you 357, the heading, summary of conclusions, and then overleaf, please, if you could just read internal paragraphs 12 to 15. Now, Sternham, of course, was about non-pecuniary damages for technical breaches of Article 5.4. So far as we know, there has been no equivalent survey by an English court of Strasbourg's approach to awarding non-pecuniary damages for breaches of Article 14. And so it's with that in mind that we have produced the table, same sort of exercise that Lord Reed commended in Sternham. And what we've done is to summarise what we think is every award of non-pecuniary damages for breach of Article 14 since 2015.
In Hobbs, the court, notwithstanding the claim of £4,000 for anguish and loss of sleep as a result of the discrimination, concluded that the applicants had produced no evidence to substantiate their claims.
Yes. Sometimes Strasbourg rejects the claim for non-pecuniary damages because of the absence of evidence. I accept that. And one can then read in, and we can't infer the distress. Because in other cases, Strasbourg has inferred distress without direct evidence. Could I just check that the court received a copy of the table?
Yes.
Yes.
Thank you. I'm very grateful to Ms. Christie for it. We say that 3 principles can be derived from those cases. The first is that awards of non-pecuniary damages are not parasitic in Article 14 claims on claims for pecuniary loss. And so, for example, in JD against the UK, the bedroom tax case, when it went to Strasbourg, there was no claim for pecuniary damages, no doubt because the individuals had received discretionary housing payments, which meant they hadn't suffered financial loss. But the European Court made an award of €10,000 non-pecuniary loss or distress. The second principle that we derive is that the court appears to approach matters on a broad brush basis. It uses words like what is reasonable, number 16, case number 16, what is equitable, case number 18, and considerations of fairness, case number 20. What the European Court, so far as we can see, has never found it necessary to do is to identify the mental process by which the breach of Article 14 gave rise to distress. And then third, just as Lord Reed identified in Sternum, in the context of Article 5.4 and Article 6.1, the European Court, in my submission, is willing to infer that applicants have suffered frustration and distress. In 9 of the cases in the table, the court stated that it considered that the applicants must have suffered non-pecuniary damage. I can give you the case numbers if it helps, but may not want.
We'll see them. It's identified in the notes.
It's identified in the notes. Yeah. So in light of those principles, we say that it was perfectly open to the judge to award non-pecuniary damages, whether or not it was open to him to award pecuniary damages. There was ample material before the judge as to the distress suffered by the respondents from not having their recovery needs met. Ample material in the witness statements as to that. And the stress of trying to bring their children to legal and medical appointments. I'm not going to try and turn up that material or even give you the references unless you want them. And in my submission, it was also perfectly open to the judge to infer that the respondents must have suffered distress. Why should they, or rather, why should individuals like XY have their recovery needs met, but not me?
If they were aware of the difference.
Well, they were aware of the difference because there was a considerable period of pre-action correspondence culminating in the claim.
Once they'd gone to their lawyers, they were aware of the difference.
Well, at least, but I can't say they were aware before that, but at least when they consulted lawyers, which is within the period of discrimination.
Anything else on non-pecuniary?
No, thank you.
Just the time.
Indirect discrimination.
Yes.
Beginning with orthodox indirect discrimination, the rule in issue, so if one were to use the language of Section 19 of the Equality Act, the PCP, was the rule that you don't get the child element if you get asylum support. The pool is asylum-seeking victims of trafficking with dependent children. That is, everyone caught by the rule.
Well, it's limited to that.
That's the pool. Can I before my lady
So
questions?
it's direct discrimination.
No, can I then no, that's the pool within which I'm going to conduct a comparison of the two groups.
Sorry, the pool, I just said the pool is asylum-seeking victims of trafficking with dependent children.
Yes. Within that pool, the rule applies to both men and women. That's why it's indirect. The question was whether within that pool, the rule put women at a particular disadvantage.
This isn't how the judge analysed it.
It's, I'm not going to try and defend the judge's language in paragraph 92 to 95. I can't. But this is how it was pleaded, this is how it was put, and it's
Fair
how
enough.
I put
Yeah.
it now.
Okay, no, fair enough. I just wanted to make that clear. Yeah.
The respondent's case was founded on two propositions. Proposition 1, lone parents affected by the rule are more disadvantaged by the rule than co-parents because of their need, their particular need, to pay for childcare to attend recovery-related appointments. That was the first proposition. The second proposition, women affected by the rule are more likely to be lone parents than men affected by the rule. And if those two propositions are made out, then the respondents will establish that the rule puts women at a particular disadvantage. And that, in my submission, is a paradigm form of indirect discrimination. It's the second formulation of indirect discrimination identified by this court in Salvato, that my lord referred to yesterday, where the court accepted that the judge had been entitled to conclude that a rule that childcare had to be paid for before it could be claimed back through universal credit had a greater adverse effect on women than men because women had lower median earnings and were therefore less able to pay for childcare up front. The same kind of indirect discrimination. And just Mr. Tam took some points about this yesterday. I want to be clear that this was the pleaded case. In EH didn't raise indirect discrimination, MD did. This was MD's pleaded case. And it was the case advanced at the hearing below, and it's the case I still advance now.
But the judge records you abandoning that in favour of his formulation.
I don't accept that. Could I show you how the judge summarised my argument? Because I say that he summarised the argument correctly. He then just didn't quite reason it through in the way that I have. And if you could please then go back to the judgment at Core Bundle, page 110. Paragraph 50, which deals with the second matter of complaint, that is indirect discrimination. In my submission, the judge correctly identified my submission.
That's 1 and 2.
Sorry?
That's your propositions 1 and 2.
Yes, exactly. Paragraph 54, he makes the finding that makes out the first proposition. Then page 115,
So sorry, where did you say he makes the necessary finding?
page 115, page 110, paragraph 54. And I'm talking about the first sentence, not
The third sentence?
first sentence.
First sentence.
I'm not talking about the latter part of paragraph 54.
I'm being slow. Why does the first sentence make good your first proposition?
Because it's referring back to paragraph 53 and it records that single parents, like the respondents,
Oh, I see.
have
Yep,
to go to
okay.
childcare. So that's the first proposition. Then page 115. Paragraph 90 The judge, again in my submission, correctly identified the indirect discrimination alleged. The exclusionary rule has a greater adverse effect on women because they're more likely to be lone parents.
Sorry, again, I was just behind you. Which paragraph?
Page 115, paragraph 90.
Yeah.
And then paragraph 91, he identified a survey by the Salvation Army. The 24% and 3% are irrelevant for present purposes. What matters is that women were usually single parents and men with children were accompanied by female partners. And that, in my submission, the judge was entitled to accept established the second proposition. But more importantly, for present purposes, the appellant didn't dispute the second proposition, and that's confirmed in her skeleton argument in this court. I'll just give you the reference. Core bundle, page 32, paragraph 4.4. I should say that there was also other evidence in the witness statements to support the second proposition, which I could give you the references for, but I really don't think is necessary.
Okay.
So having established the two propositions, in my submission, it's established that the rule put women at a particular disadvantage, and it was therefore for the Secretary of State to show that the rule was justified. Now, as I've already said, I confess that I find paragraphs 93 to 96 of the judgment slightly difficult to follow. For example, the last sentence of paragraph
Well, no need to.
Well,
time is short.
Fine. That's why we put in a respondent's notice.
Yeah.
And can I just also, in fairness to the judge, I won't necessarily take you to it now, in his reasons in support of his order, core bundle, page 100, paragraphs 10 to 12, that his analysis in those paragraphs is unimpeachable.
Just give us the page of the bundle.
Page 100, core bundle,
Thank you.
paragraphs 10 to 12.
Yeah.
So can I then just deal with justification? I accept the Secretary of State's criticism that the judge wrongly elided the test of justification in respect of direct and indirect discrimination, paragraph 98 of his judgment. What has to be justified, as I submitted below, in an indirect discrimination case like is the rule rather than the difference in treatment. In my submission, that error is immaterial, and I say that because the direct discrimination claim concerns the differential treatment of victims who receive asylum support. That was the essence of the rule. Given that the Secretary of State accepts the judge's conclusion that the differential treatment of victims who receive asylum support is unjustified, it's very difficult in my submission to see how she could establish that the rule is justified. And in any event, the Secretary of State now accepts that female victims of trafficking must have their needs met. That's the proposed new system. And if a woman needs childcare to attend appointments under the new scheme, she'll presumably get it. If one plugs that factor into the Bank-Mellot stages of analysis, it's very difficult to see how justification of the rule could be made out. So for those reasons, we say that the judge was right to conclude that the rule results in unjustified indirect discrimination, even if the reasons he gave were imperfect. Now, if you accept that, you don't need to go to Flemenos. Could I, in 2 minutes, just give you the bones of the Flemenos argument if you reject my submission on indirect? this is the respondent's notice, paragraph 6. You've got a description of Philomenos discrimination in SG, Lord Reed, Authority Volume 1, tab 16, paragraph 12. And you've got an example of Philomenos in Kay's case. The Secretary of State hasn't disputed that being a lone parent constitutes an other status within the meaning of Article 14. Detailed grounds of defence, core bundle, page 196, paragraph 67. And my submission is a simple one. It's founded on paragraphs 52 to 54 of the judgment below. Lone parent victims have a need for paid childcare in order to attend recovery-related appointments, which co-parents don't have. Or are less likely. And in the context of a scheme which is designed or intended to secure a victim's recovery, lone parent victims are therefore in a significantly different situation to co-parent victims. That has to be seen, has to be judged in the context of the scheme in issue. The Secretary of State has now recognised through the proposed replacement scheme that individual needs of this kind should be met, and in those circumstances, the failure to make adjustments to meet the different needs of lone parents, in my submission, can't be justified.
Yes, well, I think that's the core of it, isn't it?
Well, that's it. That's all I wanted to say, unless there are any questions.
No, thank you. That's been both succinct and extremely clear. Thank you very much, Mr. Butler. Well, see how you do, Mr. Tam.
Lord, I'll do
you
my
may
best.
find us cautiously indulgent if you run up against the buffers at 1 o'clock, but you won't have much longer, if at all.
I'm grateful. May it please the court. Can I first of all deal with a number of points that I was specifically asked yesterday?
Yes.
First of all, the terms of the declaration. We do make one point, which is worth noting from the terms of it. It doesn't actually say anything about withholding anything from the respondents. It is about not making an overpayment.
Sorry, I know you're wanting to be brief, but I think we've got to have it in front of us to understand your point.
Yes, this is core bundle, page 98.
Yes.
It's the non-payment of additional financial support.
So you're making a point about the difference in the word non-payment and the word withholding?
Yes, because because what is happening here is that Group 3 are being paid in total twice their essential living needs. Group 2 are being paid their essential living needs once. And it's a non-payment of the second tranche, the duplicate tranche, that is the subject of this declaration.
Okay.
And I mean, perhaps I can say this: that difference, although it may appear to be semantic, does reflect a common theme throughout the case, and I'll touch on it several times in my reply.
Yeah.
The complaint that the respondents have is that they say these recovery needs are not being met because the current scheme is not paying for them. On a basic level, one understands that complaint. The problem is that it's being the claimant or the respondents are trying to shoehorn this into an Article 14 framework, and it just doesn't work. And that's the theme that you'll see going all the way through. Yes, there was a fault in the policy, but that is not something on which the respondents can really hang their basic complaint.
When you say there was a fault in the policy, you mean the one you've always accepted.
Well, we've accepted that, and that's the way it's been put. I can't really resolve from that now. Now that we know what we know, life might have been different if we'd had the adjournment and we put our case in a different way. So I'm going to accept what was accepted below and not resolve from that. But it's not something on which the respondents can hang their real complaint, which is that the policy ought to have provided more for the extra recovery needs that they say they have.
Hang on one second. Yeah.
On the declaration itself, there was a point about whether the Secretary of State was acting unlawfully in not complying with the declaration. We respectfully say that that's actually a misunderstanding of what a declaration is. The Secretary of State was acting unlawfully on the 23rd of May, the day before the order was made, and on the 24th, the day of the order, and on the 25th, the day after the order was made. All the declaration does is to reflect that continuing state of affairs. The declaration itself doesn't make the Secretary of State's actions unlawful. Neither does a declaration compel the Secretary of State to do anything. That, it is well recognised in the law of remedies, is something which it is for the Secretary of State to sort out. Now, there are some other cases where a declaration might be accompanied by a mandatory order. So, for example, if the Secretary of State doesn't make an asylum decision fast enough, the remedy might be a declaration that the Secretary of State has been unlawful in unreasonably delaying the decision, and a mandatory order that the Secretary of State must, within, say, 3 months or 3 weeks or whatever, make a new decision. It is a mandatory order which would create the compulsion from the court.
We're getting into quite deep waters. It is, I think, generally understood by this court that where a declaration is made the Secretary of State is acting unlawfully, the Secretary of State will correct the unlawfulness.
Yes.
And sometimes, although I don't think it's ever really been properly analysed, but the reality is everyone realises it can't be put right instanter.
Yeah, exactly.
And it's analysed in terms of, well, get on with this as quickly as possible. There are plenty of examples of that.
Yes.
But as a matter of strict analysis, the Secretary of State ought to put it right at once. It's only the inability to do so practically that creates a sort of pragmatic indulgence.
In an ideal world, of course, the Secretary of State would immediately put right that which has been recognised is unlawful. But the point that Malone and Friend was making was that the failure to comply with the declaration is itself an unlawfulness which is to be measured.
I wonder whether we can't deal with that this way. Unless I've misunderstood him, I quite understand why he made the point. It really actually doesn't affect the issues that we have to decide, and I don't really want to explore this in the context of a reply. You say it's not as simple as that. We'll leave it there. Yeah.
Okay. Thank you. I'm grateful. The next point, a short one, we were looking to see whether or not the judge mentioned the back payment system. We can't find a reference to that, so my initial recollection was wrong. I apologise for that.
Sorry, I was too busy writing down the last point. What was this point again?
I'm sorry. We promised to look to see whether or not the judge had mentioned the back payments system. There was mention in Ms. Tan's witness statement about the back payments, but the judge did not himself refer to that system as far as we can see. So I'm sorry that I misremembered.
No, don't worry.
The third point on which I was asked was the authority on whether you can have simultaneously direct and indirect discrimination based on the same conduct if the ground of the discrimination is different. I have to say, in the time available, we have not been able to find a case which positively demonstrates that that can be done. the cases which we did find were all about direct and indirect on the same ground, and
Yes.
we know that can't be done. However, we can see that the conceptual difficulty that relates to the same ground may not apply where the two grounds are different. And so I think I'll probably just have to leave that there. As
I'm noting you down. You tell me if this isn't the nuance is right. You're not pressing that point.
I don't think I can properly press that now, because we have in any event made our substantive submissions about why it's not indirect discrimination in any event, and or how the judge got it wrong with respect. Then there's a fourth point about the numerical balance between the groups. My learned friend quite rightly says that the figure that we gave you, indicate yesterday, of several dozen is unevidenced. It wouldn't be right for us to try and do that. But whether it's that figure or the figure that was referred to or a figure derived from the figure referred to in the application for permission to appeal, what it makes clear is that this is not a situation where 99 people are being paid the extra money and the claimant is the one person who isn't and can claim to be the victim of discrimination. Can I then turn to the substantive submissions, and I'll try and do this in the logical order. The first is that my learned friend's proffered approach to damages for Article 14 cases, that say you pay Article 14 damages unless the two conditions are met, completely reverses the approach that the statute requires to be taken to damages in human rights cases. Article 14 is no different from any other article, and indeed the observations in the Article 14 cases themselves, like Wilkinson, show that there is no difference in principle where Article 14 is concerned. And so we respectfully invite the court to reject that approach. One ought to adhere to what is said in those cases, which is that you're looking to see whether or not the discrimination has done some harm to the claimant. And if there is some harm and it's akin in a broad sense to a common law tort in doing that, then there might be a claim for damages. But it's only in cases like that where it is necessary to award damages. The second thing is to address, and there are probably quite a lot of points to make about this, the submission that learned friend made that you can see that harm has been done because if the discrimination had been recognised earlier, then there would have been levelling up, as he puts it. The first thing that we would say is that that is, with respect, an entirely unreal submission to make in the context of this case. Because the time at which this question ought to be being considered is the time when the defective policy was being formulated. If Article 14 had been complied with, it would not have been defective for Article 14 reasons. And so the real question is, well, how would the policy have been formulated if this Article 14 problem had been anticipated and dealt with in advance? And the clear answer to that is that the Secretary of State would not have formulated a policy that allowed Group 3 victims to be paid essential living needs twice by the state. It is not, the answer is not, that the Secretary of State would have said, oh, I must now immediately introduce a recovery needs-based policy. Because what was being done then was to put in place a policy of the kind that was that we have, and it would have been drafted in such a way as to eliminate the accidental overpayment. I've mentioned a lot of reasons in opening as to why that must have been the case, and I'm not going to repeat them all here. But there's one shining point that makes that point good above all others. If it had been appreciated, then the one thing the Secretary of State would clearly not have done is to have some policy that paid more public funds for duplicate payments of essential living needs. And that's why we say, with respect, that this is an entirely unreal submission to make. Learned Friend then seeks to suggest that there would be levelling up because under the new policy, these respondents will get more than what they are getting now. Again, with respect, that is not a submission that can be properly sustained because, first of all, we don't know what the new policy is actually going to be in its detailed terms or what provision it's going to make. And we do not know, for example, whether or not, even if the Secretary of State recognises that there are these additional recovery needs, that there will be a cash payment made for them.
There is an indication in the documents that recovery needs will be, there'll be a needs assessment and they will be paid.
There will be a needs assessment. I accept. It may be paid in cash. It may be done in some other way. We don't know because we don't know the detail of the new policy. Learned Friend is, with respect, speculating that the outcome of all of this will be that, first of all, the Secretary of State will say there are recovery needs that are not currently being met, and two, there will be a financial payment to cover those. That is just premature to be speculating about that. So we respectfully say that that is not a submission which can be relied on as anything more than speculation about the future. We say that indeed one of the things that was absent from the present claim, the theme coming back, absent from the present claim is a straightforward claim, for example, that the recovery needs that the Secretary of State is already obliged to meet were not met in the respondent's case, because that could have been addressed head-on as the real complaint in the case, but instead what we were dealing with was this Article 14 claim, fundamentally based on a comparison with non-asylum seekers on mainstream benefits. A further submission is that even if the court were to consider that the respondents will get more under the new scheme, that still does not mean that they have suffered pecuniary loss that must lead to an award of damages. I say must because of the word necessary, that must lead to an award of damages. The reason is this: the extra money that they would be hypothetically paid under the new system would be for extra recovery costs that are not currently being paid for. But that has no bearing, logically, on whether the respondents should get damages for only being paid one lot of essential living needs so far, as opposed to the two lots of essential living needs that Group 3 claimants get. And so the damage that they have suffered by the wrong, the Article 14 wrong that's done, is not measured by what their extra recovery needs are. Again, you see the theme. The complaint is about the extra recovery needs. And so, in fact, looking at that really underlines that the claim is for there being too little money overall. Can I return briefly to the question of what would have happened if the Secretary of State had complied with Article 14 earlier? And there's a point to be made here which is actually linked to the question of damages and the wrong done. In a very real sense, we say analytically, Article 14 is the wrong end of the telescope to be looking at this. On the basis that the policy is faulty, and I'm not going to resolve from that, as I've said, on the basis that the policy is faulty, it would be a faulty policy even if the Human Rights Act didn't exist, and even if the convention didn't exist. It would be faulty because it's doing something that is not sensible. If the Secretary of State had recognised that this proposed policy was faulty when it was proposed, it would have been adjusted to correct the fault by not including the anomaly that was being proposed and has in fact been implemented. None of that is anything to do with Article 14 or the ECHR. Article 14 comes into it because as an effect of that fault, it can be analysed as a violation of Article 14.
Well, the obligation is being suggested is to correct the discrimination.
Yes, there would be an obligation to correct the fault in the policy anyway, because...
well, I dare say, but what if it said that in order to correct the discrimination, you must do more than correct this anomaly, which I think is what is being said.
Well, the anomaly is the cause of the discrimination. So correcting the discrimination or correcting the anomaly are the same thing. So, if hypothetically there had been no Human Rights Act, one might ask, well, what would the claim have been? And we say the claim might have been formulated as irrationality. I see that irrationality was one of the things the judge did. He didn't actually like the term because he thought it wasn't quite right for describing an accidental mistake in a policy. But there'll be some public law basis like that for criticising a policy that does not make sense. And so the reality of this is that it always was fundamentally a public law challenge to a policy which, as a matter of public law, didn't make sense. The reason, or perhaps I should say, that is also reflected in the fact that the remedy that was given, which we don't challenge as a classically public law remedy, a declaration of the unlawfulness. And indeed, we say that the answer to the question, is this really a public law type of case or is it just a damages case, can't depend on exactly what remedy the claimants happen to have claimed, or for that matter, the remedy that counsel happen to agree should go into the order after the judge has given judgment and reasons. Because the reality of the situation is that it is a policy with an anomaly. It could be described as irrational even if our judge didn't like that term. The reason it's been cast as an Article 14 claim is probably, I'm trying not to be too cynical, is probably because as an irrationality claim you don't get damages. Under Article 14 you might. But the nature of the claim and the nature of the damage being done is still, in a case like this, an entirely conventional public law analysis. And that's the framework in which we respectfully say the court needs to look at the question of whether the discrimination has done some harm to the individual. It cannot be as simple as there was a breach of Article 14, therefore there should be damages unless the Secretary of State escapes from it in some way. The next point relates to the new scheme. Learned Friend's submissions repeatedly suggest that it is the finding in this case that has caused the new scheme to be brought about. I hope that the evidence has made it clear that that is far from the case. If the present case were the only problem in the trafficking support scheme, then there might have been a much simpler fix. We've actually toyed with some ideas as to what might have been done. The litigation that has been raging in these courts suggests that there was a need for some pretty fundamental reform, and that is what is being brought about. And so when Learned Friend says that there is an entitlement to damages because it's a policy choice to bring in a new scheme together and that's taking time, that we respectfully say is not the right way of looking at it. The new scheme will correct the anomaly, and there are good reasons for introducing a new scheme altogether, which go wider than the particular subject matter of this case.
No, we have that point.
Great. The next point relates to the time frame within which one should look at the counterfactual situation, as proposed. Learned Friends' submissions, for understandable reasons, concentrate on the facts of the respondents' individual cases and when they suffered their particular detriment. But we respectfully say that if you're looking at a fault in a policy overall, you do need to consider the whole range of cases. And that is why we have taken pains to explain to the court not only the Group 2 and Group 3, which were the particular focus of the respondents' cases, but also the Group 1, the people who don't get anything else. They're pure victims of trafficking, and for that matter, who are typically going to be people who can't work, they have no leave, no permission to do so, won't get any other benefits, and for that matter, as frequently complained of in this court, can't get a driving license, can't open a bank account, can't rent a flat, all these things. And so their situation is also part of this picture. There is a lot to be gained, we respectfully say, by looking also at Group 1, as I have done. I'm not going to repeat the submissions that I made about that. Certainly one thing you cannot do is to look only at these two claimants, because the arguments apply to the generality of the group that they're in and the generality of the whole range of victims of trafficking with their different situations, and we've tried to break that down into groups for ease of analysis. So those are the reply points on the main case. Can I then turn to the new factual case, if I may describe it like that, which is an attempt to resurrect the factual argument below. We respectfully say, first of all, there's nothing in these submissions which should lead this court to say the judge was wrong in the requisite sense, as Learned Friend is trying to do. Second, a great deal of Learned Friend's submissions was directed to showing that, as he puts it, there was no means testing of any of this. When he says that it was only Group 2, the asylum seekers, who had this set-off in place, we respectfully say that that ignores the reality of what happens to Group 1 claimants, because they have nothing, typically, against which any set-off could be made. If they're victims of trafficking, the trafficking support will typically be the only state support that they get. And when you look at that and you see what Group 2 gets, you can see that there is no targeting, no adverse effect, no detriment to Group 2 claimants. Second, we had the small disagreement about MD's child payments and the back payments. I'm not going to revisit.
No, but honestly, non-point.
No, but can I ask the court to look quickly at the grounds of claim in EH's case, which set out the way that the fundamental basis on which this claim has been approached throughout. Core bundle page 283, please. Relevant section.
Yes.
At the very bottom of that page, the claim concerns the lawfulness of the rate of payments made between June 2017 and August 2020. So that's a long period covering the various changes. At 285, paragraph 58, At all material times, the defendant's policy has been to make child trafficking payments to all victims of modern slavery except those in receipt of asylum support. So the approach that is now being taken at the present time is one which certainly the claimant EH has expressly accepted, has been there throughout. That is, of course, entirely consistent with the correspondence that you've seen between the Home Office and the Salvation Army, setting out what they both understood the contract to mean. And it is therefore clear that this routing mechanism has always been in place. And the intention, the current intention, had always been in place. These were payments towards essential living needs.
Despite the fact, is it accepted, I know nobody's actually got the figures out yet, that there was a period until April 2020, when the essential living needs element as regards children was higher for asylum seekers than it was for victims of trafficking. £39.60, or perhaps marginally smaller sums if you go back, but we're told much less until a much smaller figure appears in the VC in the victim care contract, it's 20 something.
Before April 2020, what the trafficking support system paid was those lower amounts, the child benefit amounts, if I can describe them like that.
Why do you call them the child benefit amounts?
Because they were aligned to child benefit.
Oh, I see. Have you told us that before? I hadn't taken it in.
No, it was somewhere. I think we may not have mentioned it because it's been common ground throughout.
Yes,
they were aligned to child benefit rates.
Thank you. I'm sorry, I hadn't taken that in. So really what happened in April 2020 is that instead of being aligned to child benefits, they were aligned to asylum support.
That's right. And so before April 2020, asylum seekers and Group 1 victims would have to look elsewhere for the remainder of essential living needs to be covered.
Can you just help me on this? Is there an apparent reason apparent from the evidence, or apparent as common sense, but I just haven't spotted it, why it was decided to move from taking child benefit as the marker of essential living needs to taking asylum support? Is it that child benefit had disappeared under universal credit, or?
No, I don't think there's any evidence in it, but this was, of course, the start of the pandemic. The 3960 rate was actually introduced without legislation. We'll provide a note about that. Without specifically amending regulations to do it. But
if there isn't evidence, that's fine.
But the inference that we say can clearly be drawn is that the intention was to make sure the trafficking support scheme paid all of the essential living needs of the children, because there's no other obvious reason for aligning this rate by an uplift.
I mean, your essential point is it's clearly always intended only for essential living needs. The fact that different views taken as to what the quantum of those needs is doesn't affect the point of principle.
Yes. But
right?
before that, it would have been a contribution towards the essential living needs. Now it covers essential living needs.
Yes. Okay.
The point
to be fair, you did make this point first time round.
Yes. The point is, well, the point is that this is actually the ultimate question here. Was the 3960 for essential living needs? Learned Friends' submissions are trying to say the judge was wrong to find that, and we respectfully say that actually the submissions do not go anywhere near establishing that.
Just one moment, Mr. Tan. You can have another. You can go to 1:10.
Oh, I'm very grateful. That's very kind. Thank you. The next point that Learned Friend makes is that there was another alternative source of support, namely local authorities and under the Children Act, the scheme. And he relies on that for the submission that therefore the payments for children under the trafficking support scheme were intended to be a supplement to essential living needs. Again, we respectfully say that that is quite unreal. An illustration of the approach that local authorities take, you see in one of the cases in the bundle, which is PO, it's Authorities 1 tab 14. From the digest report, you'll see halfway through the head note of the facts that the whole family were overstayers with no means of support. And then if you go on beyond that into the transcript we have of the judgment to page 412 of the bundle.
Sorry, what was the passage in the digest that you just wanted
Yes,
to
it's
note?
halfway through the paragraph. The claimant children, 3
Yeah,
stairs.
got it. Overstairs. No.
and
Okay,
overstairs
thank
no
you.
means of support. And then if you go to page 412, paragraph 6, you'll see, faced with their imminent homelessness, council recognised in practice that the family was destitute and that the claimants were children in need. Now, that's entirely unsurprising that the council should take that approach, but you just have to look at that and then ask yourself the question, well, what if a victim of trafficking was getting £39.60 a week for the children, and then they go to the local authority and say, oh, we would like Section 17 help as well. The local authority would say, you're already getting it, why should we pay that? The practical effect is that local authorities and the Home Office sometimes don't know what each other are doing, they don't know the policies, they don't know the criteria that each local authority is using, and of course victims or claimants don't necessarily tell either authority everything.
But is your point, so I can understand it, it should not be assumed that local authorities, is this right, what they can pay under Section 17 is discretionary?
Yes.
And as long as they are aware that £39.60 is being paid, that will be netted off in some way or taken into account in what they decide to pay. Is that what you're saying?
That's right. And that is what one would expect.
Okay.
It is another example of the complex interaction there can be between different systems that are both intended to go towards the same end, but run by different bodies with each with their own rules and policies. So this is not a reason for saying that the judge was wrong to find what he did. Learned Friend then made the point, an alternative submission, that even if the 3960 introduced in April 2020 shows that that was for essential living needs, the previous rates were not. And so there was no anomaly until April 2020. We respectfully say you just need to look at the March and April policies to see that the only real change was in numbers. The intention, what is this payment for, cannot have changed during that period or indeed over the previous period at all. So there's nothing in that point. Lord put a number of points to Learned Friend about the way in which one should analyse the increase in the costs of recovery, in the costs of the recovery needs of the claimants, and why the children increase those needs. We entirely see that there might be arguments as to why having children increases the costs of your recovery needs. But once again, the answer to that is to make a claim that what's being paid to you is insufficient, and the scheme does not provide fully for your recovery needs.
You mean a judicial review?
A judicial review claim. So you might say, for example, it's that the scheme makes irrationally low awards.
Yeah,
it's not enough.
We have the point. It's a point you made before. Yes.
but that's not this case, and it doesn't lead to a conclusion that you should pay damages for the fact that other people get twice essential living needs, but I only get them once. Can I then go to non-pecuniary damages? The evidence is all about the frustration of not having enough money to meet what they say they need. There is no evidence, I think I've made the point, that there's no evidence about the frustration being from the discrimination. But we respectfully adopt the point that actually there's no evidence that they even knew that anybody else was getting too much, at least until they went to their lawyers. And so that is not a basis for claiming non-pecuniary damages. Yes, the other point was about the table, but I think I've already made the point that it doesn't deal at all with non-awards, and so I don't need to repeat that.
Yes. Now, what about indirect discrimination?
Now, in paragraph 5 of the judgment, this is page this way, core bundle page 103. There was a record by the judge of a distinct change in the way in which the claimants, respondents, were putting their case. And can I particularly draw attention to the penultimate line, because the way that that case was then put, the judge's analysis was put, received less money each week than others not seeking asylum. So the comparison that the judge was using was clearly between those seeking asylum and those who are not seeking asylum. And that was what had been adopted by the claimants. I accept, of course, that the description later in the judgment, paragraphs 48 to 50, was of the pleaded case that Learned Friend has now outlined.
You're effectively, are you saying that Mr. Butler had abandoned his pleaded case and can't now revive it here?
Yes, yes.
Okay. Suppose we don't accept that submission.
Well, then I have to address that analysis, and I'll try and do as much as I can about this in 5 minutes.
Well, he did it in quite a short time. So I expect you'll be able to.
Yeah, because these are all logical points I should be able to make. The first point to make is that the way it's now put is that the pool that you're looking at is all asylum-seeking victims with children. So there's no comparison outside asylum seekers. So non-asylum seekers are completely irrelevant. And that it is entirely within that pool that there is a particular disadvantage. The first thing that we would say is that the PCP complained of is just, it's a measure that affects everybody equally. And I say it's a measure that affects everybody equally. It's not in the sense of there being a height requirement or a colour vision requirement, where some people are going to pass and some people are going to fail. You're not looking at a situation where there's an advantaged group and a disadvantaged group. Everybody here gets the same amount of money under the PCP that is being complained of. So that is that there's no form of treatment that one can say goes one way or the other. So that's the first point to make.
This is a not treating different cases differently, isn't it?
This,
rather than a differentially applied to like cases.
well, what Learned Friend is saying is that this pool happens to have different components, and that some people feel this particular measure more than others.
It impacts more harshly on lone parent women, lone parents who happen more likely to be women.
Yes, that's right.
Than it does on men who happen more likely to be
co-parents. That's right. But there are within that pool, there is no distinction. There is no division within the group between people who satisfy a requirement and people who don't satisfy a requirement. So it's very hard to judge whether it is having a disproportionately prejudicial effect on a particular group, judged by that measure. Because typically, indirect discrimination involves looking at something and seeing who passes and who fails. And that is simply not the case here. So for that reason, we say that there is no discrimination at all. But logically, the next step is that even if that in itself, that's say the absence of a distinction between an advantage group and disadvantage group, simply something being applied to everybody, could amount prima facie to indirect discrimination, then within this pool, there is a clear justification for that, which is the need to pay for essential living needs once. That is a public interest which is promoted. Well, sorry, I don't need to elaborate on that really. You pay for essential living needs, you pay it once. And it justifies the fact that different people in different circumstances may feel that in different ways. It's the same reason why you pay a flat rate of benefits under various benefits to everybody. Some people will find it more valuable than others. But that is the same public interest. The complaint, as ever, is that actually they would like more money because they've got recovery needs that are not met. But that's got nothing to do with paying essential living needs once to this particular pool. And so on either basis, that is either not indirect discrimination or justified.
Well, that was very elegantly done. It's exactly 10 past 1. We are expecting, I think, I haven't kept a note, but those behind you will, 1 or 2 materials from you still.
Yes.
Documents setting out which regulations apply, a note setting out which regulations apply and what benefits are payable under them at the dates with which we are concerned, with the supporting materials so far as we haven't already got them. Good. I think that's the only thing, isn't it?
And any observations that we may have on the direct or the retained EU legislation,
yes,
beyond saying that it is
becoming clearer and clearer. That's not really an issue. But since the work has nearly been done, I think it would be useful for our own education to know what the position is. Very well. We will.
Michael, could I just flag that you asked a question about housing benefit? Could I just point out that I didn't address it orally, but it's in our skeleton at paragraphs 30 to 31.
Did I ask Chris about housing benefit?
Sorry. I always say this. Child benefit.
Child benefit. Thank you very much. Child benefit in skeleton where?
30 to 31. Paragraphs 30 to 31.
Well, as is often the case in this sort of case, things that were rather opaque when reading the skeleton beforehand will all fall into place when we reread them in the light of the argument. Thank you. The case has been very well argued on both sides. We will, of course, have to reserve our decision. What that means, although counsel will know very well, is that copies of the judgment in draft will be sent to the parties in order that the terms of an order can be agreed and any issues that arise on the order can be resolved on the papers prior to hand down. We will, of course, also be grateful for any corrections of typographical or other minor factual errors. Thank you.
All right.